Welcome back to The Explainer. Today we're diving straight into a really fascinating judgment from the Constitutional Court of South Africa. It's a story that actually begins with a dramatic fight for fundamental civil rights, but then, completely unexpectedly, pivots into a shocking cautionary tale about court procedure. We're looking at the case of Lekolwane versus the Minister of Justice and Constitutional Development. As we walk through this today, you're going to see how a seemingly straightforward claim for equality just spiraled completely out of control. And spoiler alert, it wasn't because of the law itself, but because of how the applicants interacted with the highest court in the land.
Okay, let's start with a surprisingly small number, a 10 Rand daily allowance. It's kind of wild to think about, but this tiny sum of money sparked a massive, decade-long legal battle that ultimately ended in total disaster for the applicants. I mean, it's crazy that such a small amount of daily support could become the center of a constitutional crisis, right? But as you'll see, it's never just about the money. It's about the principle, the law, and eventually, the procedure.
So, our story kicks off back in August 1998, and it starts with some serious drama. Phineas Lekolwane and his family were just living their normal lives when a major disagreement blew up in their community. During this dispute, Phineas allegedly insulted a local chief. Now, this wasn't just a minor neighborhood squabble. Tensions just erupted. A mob formed, and the applicants' home, their business, and literally all their belongings were completely destroyed. In an instant, their entire lives were upended.
Fearing for their absolute lives, Phineas, his wife Elizabeth, and their 3 kids basically had to hit the panic button and take immediate, drastic steps to get safe. First, they laid charges of public violence against the community members who attacked them. Second, they had to pack up and flee their home entirely. And third, they ultimately sought refuge by entering protective custody in the National Witness Protection Program. They traded in their normal, everyday lives for the extreme restrictions of protective custody, all just to stay alive.
Section 1. The R10 Allowance Dispute.
All right, so once the family was securely inside the Witness Protection Program, a pretty glaring inequality popped up regarding their financial support, and this is exactly what led to the legal dispute. Under Regulation 22(1) of the Witness Protection Act, a protected person who doesn't receive income is entitled to a daily allowance of R10. Because Phineas lacked income while in custody, he got this allowance, but his wife Elizabeth and their 3 kids, they received absolutely nothing, zero. The applicants felt this was deeply unfair, arguing that it was discriminatory and that it infringed on the children's rights to proper family care, dignity, and basic food.
Desperate for this daily allowance for Elizabeth and the kids, plus years of back pay dating all the way back to 1998, the family strapped in for a grueling legal journey. In 2002, they went to the Pretoria High Court and lost. In May 2003, they appealed to the full bench of the High Court and lost again in November 2004. So desperately seeking justice, they finally knocked on the door of the Constitutional Court in April 2005, asking them to declare the regulation unconstitutional.
Section 2. Chaos at the highest court.
Right, so here is where the narrative does a complete 180. It shifts from a human rights struggle into a total procedural disaster. It all started when their application to the Constitutional Court completely failed to comply with the basic rules of how to file an appeal. But despite these blatant rule violations, the Chief Justice was incredibly generous. He actually decided to enroll the matter anyway, recognizing the potential constitutional importance of the case. He even went so far as to request the Society of Advocates to appoint this incredibly robust pro bono legal team to help the family out. We're talking 2 senior counsel, 1 junior counsel, and an attorney, all working for free. The court essentially bent over backwards here.
So, how did the applicants handle this golden ticket? Well, get this. The day before their big hearing in March, Phineas wrote to the court claiming he only just learned about it from a newspaper report. He said his lawyers never even consulted him. But when the court dug into why that happened, it turned out that the official address the applicants gave for the service of legal documents wasn't a house or an office, it was literally a garage situated near their home. They essentially made themselves completely impossible to contact.
And from there, it just snowballs into an absolutely comical timeline of chaos. On March 9th, the day of the hearing, Phineas addressed the court directly, saying he was unhappy with his free legal team. The Chief Justice granted a highly unusual postponement to August 22nd, but gave a very clear, final warning that this was their absolute last chance. Did they use the time wisely? No way. On April 4th, the first pro bono team withdrew. By May 22nd, a second legal team had been fired and a third was hired. And then, instead of actually preparing for the ultimate showdown, they waited until August 21st, literally the day before the final hearing, to file an incredibly late application for yet another postponement.
Even knowing August 22nd was their absolute final chance, the new legal team still took a remarkably lackadaisical approach. As the court noted in its judgment, the applicants and their legal representatives, rather carelessly, failed to treat the matter as one of urgency. They didn't even flag the case as urgent with the Legal Aid Board. They just completely squandered the 3-month grace period the Chief Justice had so graciously handed them.
Section 3. The Rules of Postponement.
Now, this brings us directly to the core legal mechanics of the Constitutional Court. Let me ask you this. Is a postponement actually a legal right? You might naturally assume that if you just aren't ready, if your lawyers need more time, or if legal aid is dragging its feet, you can just ask the court to reschedule your hearing. But is that a right guaranteed to you as a litigant?
The short answer is no. A postponement is strictly what the law calls an indulgence. It's never a right. An indulgence is essentially a favor or a privilege granted by the court entirely at its own discretion. The only guiding star for the court here is the interests of justice. If it's not in the interests of justice to delay proceedings, especially considering how valuable the court's time is, they simply won't grant it.
To actually get this favor, you have to pass a very specific legal test. You basically have to prove to the court that checking all these boxes justifies wasting the judiciary's time. First, you need to show good cause. You have to apply timelessly, which means well in advance, not frantically scrambling the day before. You must provide a full and satisfactory explanation for the delay. The court then weighs the prejudice to the other parties, looks at whether the delay is actively opposed, evaluates the broader public interest, and critically examines your actual prospects of winning the case. And Phineas and his team, they failed almost every single metric on this list.
Section 4. The Final Verdict.
So, what happens when you completely fail that test? Well, when the August 22nd hearing finally rolled around, the new counsel stood before the Constitutional Court and had to admit they were completely unprepared to argue the actual constitutional case. They had put all their eggs in the basket of getting another delay. And that forced the court's hand. Finding no good cause, noting the application was filed terribly late, and observing a total lack of urgency, the court decisively dropped the hammer. The application for condonation and postponement was dismissed, and on top of that, the entire appeal was struck off the roll. Just like that, the family's decade-long battle, which started with the mob destroying their home over a 10 Rand allowance, ended in an instant.
The court didn't hold back either. In their judgment, they delivered this devastating final assessment. To grant yet another postponement would have constituted a gross abuse of the processes of this court. The justices had to protect the integrity of the judicial system. It just proves that no matter how righteous your initial cause might be or how terrible your suffering was, you absolutely cannot blatantly disrespect the rules and procedures of the justice system.
Which leaves us with a pretty profound question to wrap up this explainer. When you're out there fighting for your rights, how much of your success actually depends on your story and the merits of your case, and how much relies entirely on respecting the strict procedures of the court? It's a sobering reminder that the machinery of justice requires absolute compliance to function at all. Thank you so much for joining me for this explainer. I hope this deep dive gave you a whole new perspective on how the courts really work. See you next time.